Hello, everyone. Welcome back, and thank you for joining us for today's episode, where we'll be unpacking the key rules between share block schemes and sectional title ownership. This session is designed to provide valuable insights and deepen your understanding of these two property models. Please note that the information shared in this podcast is intended for educational purposes only and does not constitute legal or financial advice. We encourage you to consult with a qualified property professional for guidance tailored to your specific circumstances. With that said, let's dive in, and we'd love to hear from you. Leave your questions and comments so we can explore these topics further in upcoming episodes.
Ever found yourself staring at a property listing, terms like share block or sectional title, jumping out and feeling like you needed, a legal degree just to grasp the basics?
Oh, absolutely. It's incredibly common.
Property ownership in South Africa, especially when we talk about shared living spaces, it can be surprisingly intricate, right? All these nuances about what you actually own, how decisions get made.
Exactly. And that's really what we want to tackle today. Our mission is to demystify these concepts for you.
Okay.
We're focusing specifically on the rules and use agreements that govern them, and also what happens when these systems share block schemes and sectional titles, either convert or sometimes even coexist.
Right, that coexistence part sounds complex.
It can be. So we're going to extract the most important nuggets of knowledge from the sources, give you a real shortcut to being well-informed, hopefully spark a few aha moments along the way.
Great. So you'll walk away with a much clearer understanding of your actual rights, your responsibilities, and crucially, how decisions really get made in these shared property environments. This isn't just definitions, it's about the practical side for you.
Precisely.
Okay, let's start at the very beginning then. Share block schemes. Most people probably think owning an apartment means owning, a piece of the building. But share blocks, fundamentally different, aren't they? They actually came before sectional title.
Indeed they did. Share block schemes have been around since the 1950s, though they were formally regulated by the Share Blocks Control Act of 1980, the SBCA.
Okay.
And here's the core difference, the bit that often surprises people. When you buy into a share block, you don't actually own a portion of the immovable property itself.
No title deed.
No title deed for the unit, no. Instead, a company acquires or develops a building, and you, as an individual, purchase shares in that company.
Oh, okay, shares.
Those shares then grant you the right to use and occupy a specific portion of that building. Your rights, your obligations, they're all spelled out in a use agreement and the company's Memorandum of Incorporation, or MOI.
So the company owns the property. You own shares, giving you rights to a part of it.
That's the essence of it.
So I own shares in a company, not the physical walls around me. That sounds like a really significant distinction, especially, I imagine, when it comes to control. How are decisions actually made? How's the property managed if I don't directly own the unit?
That's a critical point, yeah. The management of a share block scheme rests primarily with the company's board of directors.
Board. Right.
They operate within the bounds of the SBCA and the Companies Act. Now, unlike sectional title, and we'll get into that, where owners typically have a more direct say in the day-to-day running, directors in a share block scheme generally make management decisions without needing to consult the shareholders directly on every single matter. That centralized control is just inherent to the share block structure.
So your influence is more indirect. Like voting for directors at company meetings.
Exactly. Your power lies more in electing those directors rather than voting on, say, the budget line items directly.
Okay. Then came the Sectional Titles Act, first in 71, then replaced in 86. What fundamental shift did this legislation introduce? Did it address some of those, control issues?
It absolutely did. The Sectional Titles Act truly revolutionized shared ownership.
Yeah.
It allowed you to have sole ownership of your specific section.
Your actual apartment or townhouse unit.
Precisely. Be it an apartment, a townhouse, an office unit, whatever, that's yours. And it's paired with joint ownership of the common property.
That's just everything else.
Pretty much. The land, foundations, outer walls, roofs, gardens, driveways, passages, communal facilities like pools, all of that.
Okay.
And crucially, it means you receive a title deed for your section that formalizes your direct ownership of a part of the building.
A huge difference.
Massive.
Yeah.
And just to clarify, while the original Sectional Titles Act handled the creation of schemes, it's the Sectional Titles Schemes Management Act, the STSM Act from 2011, effective 2016, that now specifically governs the management and the rules of these schemes.
Got it. STSM Act for Management and Rules. So that direct ownership sounds like a game changer. How does management work then in a sectional title scheme? You mentioned direct owner participation earlier.
Yes, it's profoundly different. The moment the very first unit in a sectional title scheme is transferred to an individual owner, boom, a body corporate is automatically formed.
Automatically.
Automatically. And every single unit owner is a compulsory member of this body corporate.
Okay, so everyone's in.
Everyone's in. This body corporate is the supreme governing entity. It's responsible for the control, administration, management, everything for the entire scheme.
And how does it actually do that? Does everyone vote on everything?
Well, the owners elect a group of trustees to handle the day-to-day operations. Think of them like the executive committee. But this structure really empowers you as an owner. It gives you a direct say in how your scheme is run. You make key policy decisions at annual general meetings, AGMs, and you provide directives to those trustees.
That's a huge difference in governance compared to the share block model. What about the rules, the day-to-day stuff in a sectional title scheme? How are they created, and maybe more importantly, how can they be changed if owners want to adapt them?
Right. Rules are key. Sectional title schemes operate under two main categories: management rules and conduct rules.
Management and conduct.
Yeah. Management rules, you'll often hear them called the prescribed management rules. They're in Annexure 1 of the STSM Act regulations. They dictate the administration. Things like how trustees are elected, their duties, procedures for meetings, finances, the nuts and bolts of running the scheme.
Yeah.
Then you have the conduct rules, or prescribed conduct rules, in Annexure 2. These regulate the behavior of owners and occupiers. Think noise levels, keeping pets, refuse removal, parking, that sort of thing.
The lifestyle stuff.
Exactly. And if a scheme doesn't create its own custom rules, these prescribed ones apply by default.
But they can make their own rules.
Yeah.
Or change the default ones.
Absolutely. But, and this is important for you to note, changing them requires different levels of consensus. Management rules need a unanimous resolution.
Unanimous. Wow, that means every single owner has to agree.
Every single owner, yes. A very high threshold. It protects the fundamental governance structure.
Makes sense. And conduct rules.
Conduct rules require a special resolution. That's still significant. It means a 75% majority of votes counted in both value, based on PQ, and number, one owner, one vote.
Okay, 75%. Still tough, but achievable, perhaps. So even small changes can be quite an undertaking.
They definitely can. It ensures changes aren't made lightly.
You mentioned PQ, their participation quota. That comes up a lot in sectional title talk. Sounds a bit abstract.
Yeah.
How does it practically affect me as an owner?
It's far from abstract, actually. The participation quota, or PQ, is arguably the most direct measure of your power and your financial commitment in the scheme. Think of it like your property's DNA within the body corporate. It's your undivided share of the common property.
My slice of the shared pie.
Sort of, and it crucially determines three things for you. First, the value of your vote in many body corporate decisions, especially those requiring special or unanimous resolutions.
So bigger unit, bigger vote, generally.
Often, yes. Second, it dictates the exact proportion of your liability for contributions, what everyone calls levies, towards the administrative fund and the reserve fund.
Right, so it directly hits my pocketbook.
Directly. And third, it determines your share of any judgment debt the common property might incur, say, if someone sues the body corporate.
Wow, okay. And how's it calculated?
For residential schemes, typically it's a percentage based on your section's floor area compared to the total floor area of all sections in the scheme. It's clearly specified on a schedule attached to the scheme's sectional plan, so it's transparent.
Very clear. PQ equals financial load and voting clout. Now, one more area of rules for sectional title. Exclusive use areas. Are these part of my actual section, or are they something else? Because, my balcony feels pretty mine.
That's a really common question, and they're a fascinating hybrid. An exclusive use area, EUA, is a designated part of the common property.
Ah, common property.
Yes, that's the key. It's allocated for the exclusive use of one or more section owners. So think of a private garden attached to a ground floor unit, a dedicated parking bay, or, yes, your balcony.
So they are not part of my section.
Correct. They remain common property legally. However, you, as the designated owner, have the exclusive right to use and enjoy that specific part.
Okay. What about upkeep? Who pays for maintaining my exclusive use garden or parking spot?
That's where it gets interesting and often surprises owners. While the body corporate retains the primary responsibility for maintaining all common property, including EUAs, the owner benefiting from that exclusive use is typically required to make additional contributions. These cover the costs of rates, taxes, insurance, and maintenance specifically for their EUA.
So I pay extra on my levy for my balcony.
Usually, yes, unless the scheme's rules specifically state otherwise, which is rare, so that balcony might feel like your space, but legally it's common property you're paying extra to maintain and use exclusively. It really highlights how these rules define every square meter.
Fascinating how these rules really carve out the boundaries of ownership and responsibility. Now, historically, you mentioned many share block schemes converted to sectional title. Why? From an owner's perspective, what were the big advantages driving that trend? There must be costs involved.
Oh, definitely costs and time involved, often 6 to 12 months just for the initial stages. But the advantages of converting are usually seen as pretty significant for you as an owner.
Such as?
Primarily, you gain actual ownership of immovable property with that title deed we talked about.
Right, the tangible asset.
Exactly. This generally leads to a higher resale value compared to just owning shares. It's a more secure, understandable form of ownership for most buyers.
And financing. I imagine getting a bond is easier.
Much easier. Banks are often, let's say, hesitant to lend significant money against a pledge of shares. They much prefer the security of a mortgage bond registered over a sectional title unit.
Makes sense.
Plus, you gain that more direct control over your property and its management through your membership in the body corporate, rather than having your interests essentially controlled by a share block company's directors.
So moving from indirect rights to direct ownership and control.
That's the crux of it, yes.
But what ifs? What if a share block scheme decides to convert, but some shareholders just don't want to? Maybe they can't afford the transfer costs, or they're happy with the status quo.
Yeah.
Can a share block company and a body corporate literally operate simultaneously in the same building? That sounds messy. Two sets of rules.
Remarkably, yes, they can. It does sound messy, but the Share Blocks Control Act doesn't actually compel a shareholder to take transfer of the unit they occupy when a scheme converts.
Really? No obligation?
No obligation. This means a share block company and a body corporate can indeed operate side by side for the same property.
Wow.
So until a shareholder decides to take transfer of their unit, their rights and obligations remain with the share block company governed by the SBCA.
And who pays the levies for that unit to the body corporate?
The share block company does. It becomes liable to body corporate to pay contributions for any units that haven't been transferred, which naturally leads to that critical question.
Yeah.
How do their different sets of rules interact? Who has the final say when there's a disagreement?
Okay, yeah. So you literally have two entities governing the same physical property, each with its own rule book. What actually happens when there's a direct clash, say a body corporate rule, versus something in the share block company's MOI or use agreement? Is there a clear pecking order?
Thankfully, yes. The law provides a clear hierarchy here. Section 8.3c of the STSM Act is key. It states that if both sets of rules regulate the exact same subject matter.
The exact same thing.
Yes, the wording is important. If they regulate the exact same subject matter, then the rules of the body corporate prevail, and they are deemed to be incorporated into the memorandum or articles of the share block company.
Ah, okay. So the body corporate rules have seniority in a direct conflict.
In a direct conflict over the same subject matter, yes. It's designed to ensure consistent governance for the entire property, even with share block holders still present. The primary governing body for the physical property, the body corporate, gets the ultimate say on rules affecting everyone.
Can you give an example of how that plays out? Or maybe where it doesn't?
Sure. There's a classic case that illustrates this nuance really well. De Villiers v. Kinsale Properties Share Block Ltd. from 1988.
Okay, De Villiers. What happened?
Right. So in that scenario, you had a shareholder who hadn't converted to sectional title yet. They were denied voting rights at a share block company meeting because they were in arrears with their levies.
Levies to the share block company or the body corporate?
Good question in this context. Likely levies owed ultimately destined for the body corporate, but possibly collected via the share block company structure. Now, the body corporate's rules clearly stated that members in arrears couldn't vote in body corporate meetings.
Standard rule.
Pretty standard. But the share block company's own articles of association did not have such a restriction for voting in its meetings.
Difference.
A clear difference. So the court had to decide, was this a conflict over the exact same subject matter, which would mean the body corporate rule overrides the share block articles?
So the core question was, did the body corporate's rule about voting rights for its members in arrears automatically apply to the share block company's meetings and its members? My gut feeling says it should, for consistency, cross the building.
That's a logical thought and perhaps what you'd expect for smooth operation. But the court actually held no. It wasn't the intention of the act to just make all body corporate rules universally applicable to a share block company's internal administration simply because their rules differed.
Right.
Yes, for a conflict to exist under the Act, triggering the body corporate rules precedents, they must regulate the exact same subject matter.
And voting rights in two different entities weren't the same subject matter.
According to the court, no. The share block company's articles regulated the right of its members to vote in its general meetings. The body corporate's rules regulated the voting rights of its members in its meetings, specifically concerning levy arrears.
Two separate meetings, two separate sets of membership rights.
Exactly. Since they govern voting rights within two distinct legal entities and potentially for different internal company procedures, the court found they were not regulating the exact same subject matter in a way that caused a direct statutory conflict.
So the share block company's rules applied in that instance.
Correct. The share block company's rules for its own meetings held sway, and the shareholder could vote despite the arrears and despite the body corporate having a different rule for its meetings.
Wow. That de Villiers case is a powerful example of how incredibly nuanced these legal interpretations can be. It really shows coexistence is possible, but the lines are very finely drawn.
Precisely. It's not a blanket override. The conflict has to be specific and direct.
Okay, with all these different rules, acts, potential overlaps, and nuances like in de Villiers, it really sounds like disputes could easily pop up. Who steps in? Who helps resolve these things without everyone having to resort to expensive, drawn-out court battles?
That's exactly the problem the government sought to address, and the solution is the Community Schemes Ombud Service, or CSOS.
CSOS?
Heard of them? Yes. Established by the CSOS Act back in 2016, it's a statutory dispute resolution service specifically designed for all community schemes, and that explicitly includes both sectional title schemes and, crucially for this discussion, share block companies.
So they cover both. Good.
Absolutely. CSOS offers a much more accessible, generally cheaper, and faster alternative to going through the traditional courts for a whole range of disputes.
Like what kind of disputes?
Oh, everything from financial issues, levy disputes, access to financial records, to behavioral problems like nuisance complaints, governance issues, problems with meetings or trustees, even disagreements over repairs and maintenance.
Pretty comprehensive. And their decisions stick.
Yes, their adjudication orders are legally enforceable, just like a magistrate's court order. It provides a really critical pathway to resolution for owners and schemes.
Okay, so CSOS acts as the referee for disputes. But what about the rules themselves? Do they have any role before things go wrong?
Yeah.
Any oversight in how schemes draft or amend these rules, maybe to prevent future conflicts or ensure they're fair in the first place?
They do, absolutely. That's another vital function. Beyond just resolving disputes, CSOS is also tasked with taking custody of, keeping, and providing public access to key scheme documents.
Like the rules.
Exactly. And crucially, they are responsible for regulating, monitoring, and controlling the quality of all community scheme governance documentation. This explicitly includes the scheme's rules, both management and conduct rules.
So they check the rules.
Yes. When a developer sets up a scheme, or when a body corporate wants to amend or substitute its rules, they must lodge them with the chief ombud at CSOS. The Ombuds office then examines them
To make sure
they are reasonable and appropriate for that specific scheme and that they don't conflict unfairly with the legislation. If they pass muster, the Ombud approves them for filing.
So there's a quality control check.
Exactly. It provides an important layer of protection and helps ensure fairness for all owners and shareholders right from the rulemaking stage. It tries to make sure the rules are sound before they even go into effect and potentially cause disputes later on.
That makes a lot of sense, sort of heading off problems at the pass.
That's the idea.
Wow. We've really journeyed through the real intricacies of share block and sectional title schemes today, specifically drilling down into how their respective rules and use agreements function, how they evolve, and crucially, how they interact.
It's quite a landscape.
Yeah.
Understanding these frameworks, from those historical share-based use agreements and share blocks, which are quite different,
Right.
all the way to the direct ownership and the very detailed rule sets of sectional titles governed by the STSM Act and overseen by CSOS. It's just crucial for anyone navigating shared property.
Absolutely.
And the fact that these systems can actually coexist, like we discussed, with specific legal provisions, like in the de Villiers case, showing how that rules hierarchy works in a conflict.
Yeah.
It really just underscores the importance of being an informed owner and, frankly, reading the fine print of your scheme's documents.
Definitely. So whether you're maybe a longtime share block holder thinking about the pros and cons, perhaps considering a conversion, or you're a new sectional title owner trying to get your head around the rules, this deeper dive into the specific rule interactions, the governance structures, the role of CSOS, it really should empower you.
Hopefully, yes.
So a final thought for you to maybe mull over. What does understanding these complex interplays, the rules, the PQ, the EUAs, the potential for coexistence, what does it really mean for your ability to participate in and genuinely influence the community you live in? How might this knowledge change the questions you ask about your own property's governance? And maybe what might you discover when you actually start looking closer at your own scheme's rulebook? Something to think about until our next deep dive.
That brings us to the end of today's discussion on share block schemes rules versus sectional title ownership rules. We hope you found it informative and useful as you navigate the world of property investment and ownership. Remember, while we aim to provide clarity and insight, this content is for educational purposes only. Be sure to seek personalized guidance from a qualified property specialist for your unique circumstances. Thank you for listening. If you enjoyed this episode, feel free to share it, and don't forget to leave your questions and comments. We are always keen to explore new topics and dive deeper in future episodes. Until next time, stay informed and empowered.